A very good evening to all of you friends. On behalf of BYJU'S Exam Prep, I take the privilege of welcoming each and every one of you for today's session, which will be where we will be concentrating on Maharashtra CET Law Entrance Examination. Now, this Maharashtra CET Law Entrance Examination will be conducted in the month of April. तो आपके पास अभी जनवरी 15 दिन पकड़ लीजिए, फरवरी 29-30 दिन पकड़ लीजिए और मार्च के another 30 more days. So you have around 2.5 months effectively insofar as your preparation for this entrance examination is concerned. Now, in this session, we shall be talking to you and trying to help you out with how to solve legal reasoning question insofar as this particular entrance examination is concerned. Okay, so let's get started without wasting much of our time. And today आज हम लोग कुछ महाराष्ट्र सीईटी का जो एग्जाम होता है उसका जैसे जैसे क्वेश्चंस आते हैं वैसे क्वेश्चंस हम लोग कुछ देखेंगे हम लोगों के पास कैसे सॉल्व किया जा सकता है. So the most important thing is how to solve a particular question, and for which reason we bring to you these sessions which are going to tremendously help you insofar as your preparation is concerned. So moving on. Okay, so about the session we are going to have some 17 questions today. 17 questions हम लोग डिसाइड करेंगे, देखेंगे कि क्वेश्चंस क्या है, कैसे आंसर किया जा सकता है, उसको भी हम लोग देखेंगे and we'll move on. Okay, so let's get started. But before that, BYJU'S Exam Prep brings to you a very important session on which you can get up to 90% scholarship on BYJU'S Exam Prep courses. For that, there will be a session register. There will be a session on 22nd of January at 11 a.m. So give the scholarship test. So this will be a scholarship test. If you are successful, you can get up to 90% off on your courses. So definitely register for that and check out your luck. Moving on to the first question. Let's read the first question. Let's understand the question, the facts, and how to solve these questions. Please read. If a spouse has not been heard of as being alive for a period of at least 7 years, by such individual who would have heard about such spouse, if he or she were alive, then the spouse who is alive can obtain a judicial decree of divorce. So if the husband does not hear about the wife, whether the wife is alive or dead, for around a period of 7 years, after that he might go to the court and ask for a decree of divorce. Same thing with the wife. Facts. On 1/1/2002, so 2002, 1st of January, in order to understand true meaning of life, Rohan left his house. His wife Kanika searched for him but does not get any news about him of being alive or dead. On 14/6/2010, two dates. There are two important dates that we must have to remember. 1/1/2002, 14/6/2010, and 7 years. Calculate. Mathematics. Kanika decides to approach the court to obtain a decree of divorce. Is she entitled for the decree of divorce? Tell me, what is the correct answer? In 2002, Tell me, what is the correct answer? The correct answer is option B. Yes. Yes, she has not heard of Rohan being alive for the past 7 years. Simple. As simple as that can be. Right? Very good. Very good. ये तो पूरा मैथमेटिक्स था, ज्यादा दिक्कत नहीं हुआ होगा आपको, ठीक है? तो that's the answer, option B, right? Moving on to the next question. Read the principle, read the facts. Mere silence to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that regards being had to them, it is the duty of the person keeping silence to speak, or unless his silence is itself equivalent to speech. Eric sells a horse to Raymond, which Eric knows to be of unsound mind. The horse is of unsound mind. Raymond says that Eric, that if you do not deny it, I shall presume that the horse is sound. Eric says nothing. So he says that, if you don't say anything, I will presume that he is fantastic. He does not respond to it. Okay. So what is the correct answer to it? Now, there was a question that was made that if you do not say anything, I shall presume that the horse is absolutely perfect, fine. But the horse is suffering from unsoundness of mind. Please try to understand this. Here is a particular horse which is suffering from unsoundness of mind. And when a question is posed at the master who is trying to sell the horse, that if you do not answer, I shall presume that the horse is perfectly fine, he does not answer. Is it fraud? The correct answer is yes. It is option C. Very good, very good. Most of you, Rahi Kapoor, Saitam, Kunal, Joshna Singh, very good. So you are understanding how to solve these questions, right? The more you understand how to solve these questions, the better it shall be for you guys. Because at the end of the day, आपको पता होना चाहिए कि कैसे एक question को solve किया जा सकता है. ठीक है? Moving on to question number 3. Culpable homicide is not murder if the offender Willis deprives of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. So we are talking about provocation. Power of self-control, you are losing the power of self-control, and others. Abhishek found his wife sleeping with another man. Abhishek, deprived of the power of self-control, picked up a steel lamp lying in the room and hit Arthur in the head, who died on the spot. Now, you go back to your home and you see your wife with another gentleman. At the heat of the moment, you take up a steel lamp and you bash the man. Now, is it under sudden provocation? That is the question. Very important. Has that act been done under sudden provocation? Sorry, this is the options. This was done under sudden provocation or not? Is it murder or is it culpable homicide not amounting to murder? The question is simply over here is this. Whether such an action, now this is an action which was done under provocation. You see something, there's a heat in your mind, sudden provocation, and you do an act. Will it be called murder or will it be called culpable homicide not amounting to murder? Correct answer is very good, B. Culpable homicide not amounting to murder. Okay, very good. That's the answer. The explanation, please read it. Please read, all of you. I want each and every one of you to read all these things. It is culpable homicide not amounting to murder. Is that clear? All of you? Is that clear, everyone? Okay, moving on. But before we move on, we congratulate from the deep of our heart to ALET 2023 AIR rank 18 Anita Sehgal. She was a student of the one-year online classroom program. So many congratulations to her for achieving this great goal in her life. Moving on to question number 4. Please read the question, the principle, the facts, and let's see the answer. A violation of a legal right with or without damage gives rise to tort. Srinivas is a qualified voter at a parliamentary election, but Simon, a returning officer, wrongfully, very important, wrongfully refuses to take Srinivas's vote. No loss was suffered by such refusal because the candidate for whom Srinivas wanted to vote won in spite of that. So, I am an eligible elector, a voter. I have been denied my right to vote, but no loss has been caused owing to the fact that the party whom I wanted to vote became the winner. Is Srinivas entitled to claim damages? Now, is there a violation of a legal right? Yes, right to vote has been violated. An individual's right to vote has been violated. There has been a violation of someone's right. Thank you. Please answer. Wherever there is a violation of a legal right, you have a right to claim compensation. The law is very simple. The law very specifically says in case your rights are violated, you have a right to claim compensation. That's it. Very good. Option A is the right answer. Option A. Bharti Rajput, Rahi Kapoor, Devanshi Pandey. Many congratulations for answering it perfectly. Okay. Ritu Nikam and Kunal. Before moving ahead, BYJU'S Exam Prep brings to you a scholarship test. Get up to 90% scholarship on the BYJU'S Exam Prep programs. The scholarship is going to start at 11 a.m. on the 22nd of January. Get yourself registered and get the benefit of a 90% scholarship on the BYJU'S exams. Okay, moving on. Question number 5. Which of the following principle has been laid down in the case of Ryland versus Fletcher? Now, whenever we hear the term Ryland versus Fletcher, there is either this concept of strict liability or absolute liability. The proposition of strict liability was given in Ryland versus Fletcher, and the concept of absolute liability came out in the case of M.C. Mehta, Bhopal gas leak. right? All of you? Strict, when we are talking about strict liability, it is Ryland versus Fletcher. Am I clear? Everyone, if you bring upon your land something that is dangerous, and that dangerous thing escapes out of the land, and as a result of that escape, there is a lot of people dies and all, absolute liability. But if you bring onto your land something that is dangerous, that is not unnatural to the land. Water. What happened in this case of Ryland versus Fletcher? Water escaped from someone's water tank, enters into someone else's coal mine. The coal mine is destroyed. Remember that. So, if you join our courses, you will get more elaborate discussion on all these topics. Okay, moving on. So, that's the answer. Moving on to the next question, question number 6. Okay. हाँ, एग्जाम में फैक्ट्स के साथ प्रिंसिपल भी आते हैं. अवनी, या $16 years. A boy aged 16 years enter into a certain agreement. Is it valid? Is it not valid? Is it void? Very good. Am I clear? Have I made myself clear? Everyone. आपको समझ में आ रहा है कि कैसे आंसर किया जा सकता है? Right? All of you? Check out the answer. Just check out the answer. Okay. Moving on. BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course, which shall provide 300 recorded videos across 5 sections, 300 hours of live classes, 35 marks of CLAT and other law entrance examination, monthly e-magazine for current affairs, and contents are all based on the exclusive analysis of the last 5 years of CLAT question paper. So if you are planning for CLAT 2024, get yourself enrolled. Question number 7. The principle given over here is of absolute liability. Read it. I'm not going to read with you. Now, try to understand the principle. What does the principle say? Use the principle in the factual situation. The moment you are using the principle in the factual situation, you get the answer. Very close to Bhopal gas leak case. Very close to the Oleum gas leak case. The moment you are bringing on your land something that is superly highly dangerous, Oleum, there is an escape, people are dying. The correct answer is absolute liability. Check out the answer. It is a case of absolute liability. Is that clear? 7, the correct answer is option B. Option B. Option B. Okay. Ryland versus Fletcher was on strict liability. We are talking about something like Oleum gas leak, which is absolute liability. Question number 8. A citizen shall have the fundamental right to carry on any occupation, trade or business by reasonable restriction on the exercise of such right can be imposed by law in the interest of the general public. Ravi is the factory owner of dyeing clothes. He had been carrying on the business for the last 5 years, providing employment to about 500 people. From the factory premise, untreated chemicals were being discharged into the nearby river, causing damage to the public health. Government issued a notice to close the factory. So there is a notice to close the factory till necessary measures to protect the public health as provided under the environmental statutes were taken by Ravi. Decide the validity of this notice. So we are talking about something called reasonable restriction. You have a right to do any occupation, business, trade of your choice, but that is subject to certain reasonable restriction. And the reasonable restriction in this particular situation is you follow all the environmental norms, right? Is the notice valid, which was issued by the government, that till the time you adhere to these environmental statutes, your shop or your factory shall remain closed? That's a simple question. It is reasonable restriction. This is a situation of reasonable restriction. Okay. Please read why is the answer C correct. Many congratulations. All of you are giving me the right answer. Okay. Very good. Very good. Superb. Love it. Okay. Rutu, Viren, Arka, Joshna, Sudhanshu, Yash. Very good. Aryak Joshi. Very good, very good, very good. Before we move on, BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course. So to secure a seat in your dream NLU, get into the BYJU'S Exam Prep CLAT 2024 comprehensive course, which shall provide you with 300 recorded videos across 5 sections, 300 hours of live classes, 35 marks across CLAT and non-CLAT, along with video solutions. You shall be also provided with monthly e-magazine for current affairs, and all these questions are based on especially the mock test are based on the analysis of the last 5 years of CLAT question paper. Moving on to question number 9. What is criminal force? A, with the intention to cause fear in the mind of Mr. Z, incites his dog to spring upon Mr. Z without Mr. Z's consent. Can that be called use of criminal force? Can this be called use of criminal force? बताओ. Yes. Use of criminal force is I am instituting some fear in the minds of someone else. How am I doing it? By making a dog bark. Fair thought. Making a dog bark. Fair thought. That is. Am I clear? Am I clear to everyone? So you guys are understanding how to solve these questions. These questions are not difficult at all. ये सब question बहुत difficult नहीं है, बहुत आसान है. But you should know how to solve a particular question. Is that clear? आपको पता होना चाहिए कि कैसे एक question को solve किया जा सकता है. Okay? So guys, are you enjoying this session? Are you enjoying this session? If you are enjoying this session, do एक like तो बनता है. एक लाइक तो बनता है और आपको मैं रिक्वेस्ट करूंगा कि ये सब सेशंस को आप शेयर कीजिए. थोड़ा सा ज्यादा जितना शेयर करेंगे तो a lot of students can take advantage of these free classes. Okay? So, अगर मैं किसी के दिमाग में सुधांशु, अगर मैं किसी के दिमाग में एक फियर इंस्टॉल करता हूं, it's a use of force. As per the principle. Let's get back to question number 10. Yeah, sorry. This is the question. Every partner is liable jointly with all the other partners and also severally for all the acts of the firm done while he is a partner. Jointly, severally. Very important. Ron is a partner in a firm with Jeremy and John. The firm provides mobile repairing service. Hodor approached the firm to get his iPhone repaired and noticed that only Ron was present. Hodor explained the problem to Ron and Ron started repairing the phone. Ron matched the wrong wires which led to the spark in the motherboard. Now, Hodor sues Jeremy and John along with Ron. Jointly, severally. Jointly. Understand the meaning of jointly. For the wrong committed by one of the partners, the other partners can be held liable jointly. Whether the other two partners can be liable. Can the other two partners be held liable? Very good. The correct answer is yes. Okay. Chalo. 11. Mistake of fact is excusable, mistake of law is not. Dev sees Tarun commits what appears to Dev to be a murder. Dev, in the exercise of his best of his judgment, exerted in good faith of the power which law gives to all person of apprehending murders in the fact, seizes Tarun in order to bring Tarun before the proper authorities. Later on, It turned out that Tarun was acting in self-defense. Mistake of fact is excusable. Mistake of law is not. Read it once again. Okay. Yeah. Here is a mistake. Here is a mistake of fact. उसको समझ में आया कि वो मर्डर किया है, बट वो बंदा ना सेल्फ डिफेंस में वो हरकतें कर रहा था. This is not a mistake of law, this is a mistake of fact. Am I clear? Am I clear to each and every one of you? Are you trying to understand how to solve these questions? Okay? Very good. Question number 12. The member of both Lok Sabha and Rajya Sabha are qualified to become ministers of the Union government. Mr. Prakash is a sitting individual from the upper house, Rajya Sabha, in the parliament. And as recommended by the Prime Minister of India, the President of India designated Mr. Prakash as a minister in the Ministry of Sport. Is the appointment legitimate? Okay. A member of the Rajya Sabha as well as the Lok Sabha can become ministers. The Prime Minister say, okay, for example, you have, I think, our Finance Minister, Nirmala Sitharaman, and if I am not wrong, our Foreign Affairs Minister, Mr. S. Jaishankar, are all from Rajya Sabha. Can't they become ministers? Why not? There is a provision of the constitution which says that even members of the Rajya Sabha can become ministers. So what's wrong in that? Correct answer is yes. Not legitimate, legitimate. B. Is that clear? Everyone? Okay. Moving on to the next question, question number 13. Question number 13. Whoever voluntarily obstruct any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. The obstruction of a private way over a land or water which a person in good faith believes himself to have a lawful right to obstruct is not an offence. Arun obstructs the path along which Aman has a right to pass. Arun, believing in good faith that he has a right to stop the path, Aman is thereby prevented from passing. Okay? Please read it once again. Please read it carefully. Okay? Has Arun wrongfully restrained the other person? I think Aman, whatever his name is. There is a wrongful restraint. There is a wrongful restraint in this particular situation. There is a wrongful restraint in this particular factual situation. Am I right or wrong? Very good. Okay, please read the answer. Moving on to question number 14. An agreement to do an act impossible is in itself void. Kiran and Tarun contract to marry each other. Before the time fixed of the marriage, Tarun goes mad. Can you marry a mad person? I enter into a contract with Miss A and I say that I am going to marry you in the year 2024. In 2023, I become mad. Am I in a position to get married? No. So the contract is void. The contract is void. The correct answer is option A. The contract is void. Am I clear? आप किसी से प्रॉमिस किए हो कि आप शादी करोगे, उसके पहले आप पागल हो गए हो. The contract is void. Is that clear? (15) Very good. Civil suits can be filed where defendant resides or carries his business, or where the cause of action has a reason. Rajiv is a tradesman in Pune and Sanjeev carries on business in Indore. So Rajiv in Pune, Sanjeev in Indore. Sanjeev, by his agent, is in Pune, buys goods from Rajiv and requests Rajiv to deliver them to the Western Indian Railway Company. Rajiv delivers the goods accordingly, but Sanjeev fails to pay the agreed sum of money. So who is the defendant in this case? Sanjeev. Where does Sanjeev stays? Okay. Give me the answer. Okay, yeah. I'm ready. I am ready. Joshna Singh. C. Oh, one person says C. Let's not do that. ठीक है? तो एक इंसान रहता है पुणे और दूसरा इंसान रहता है इंदौर. प्रिंसिपल कहता है जो डिफेंडेंट है वो जहां रहता है और कॉज ऑफ एक्शन जहां हुआ है उधर का कोर्ट को ज्यूरिसडिक्शन मिलेगा. Who is the defendant? Sanjeev. Where does Sanjeev stay? इंदौर. तो इंदौर तो होगा. ओनली पुणे. नन ऑफ दी अबव तो नहीं होगा. इंदौर भी है, इंदौर और पुणे. सो बी और सी में देखते हैं विच इज द राइट आंसर. कॉज ऑफ एक्शन कहां हुआ है? पुणे में. सो द करेक्ट आंसर इज ऑप्शन सी. सी बोथ. इंदौर और पुणे both जगह में. In both the places you have jurisdiction. Question number 16. Read fast. No child below the age of 14 years shall be employed. Below 14 years shall be employed in any factory or mine or engaged in any hazardous employment. Mukesh, a 10-year-old boy. Bas, that's it. Do you have to read much? पढ़ लीजिए. मेरे को पढ़ना हो गया. Below 14 years. First line पढ़ लिया. बस. Cracker manufacturing unit. Hazardous. This is hazardous. So a 10-year-old boy is employed in a hazardous industry. बताओ सभी लोग मिलके, और सबको सही आंसर देना चाहिए. So guys, if you are liking this session, do press the like button. That's it. Yeah, fast. इतना टाइम नहीं होगा आपके पास. 10 साल के बच्चा एक हैजर्डियस इंडस्ट्री में काम कर रहा है. सही है. इज दैट क्लियर एवरीवन? सभी को समझ में आया? ओके, चलिए मूविंग ऑन टू द नेक्स्ट क्वेश्चन. क्वेश्चन नंबर 17. गिफ्ट. Gift is the transfer of certain existing movable or immovable property made voluntarily without consideration by one person called the donor to another called the donee and accepted by on behalf of the donee. A gift is valid when it is accepted by or on behalf of the donee. Manju transfers his plot of land worth rupees 20 lakhs to Bablo for building a multiplex. Bablo transfers the same amount to Manju as consideration. पढ़ लीजिए आप. All of you. A gift is without consideration. In the present fact, we see somebody giving something to someone else and the other person paying the money back. Is it a gift? इसको क्या गिफ्ट कहते हैं? This is not a gift. This is not a gift. The correct answer is option B. The correct answer is option B. Am I clear, everyone? Okay? Every one of you. So, if you have understood how to solve these questions, I request each and every one of you to like this session immediately and share this session with your friends who are also preparing for CLAT and other law entrance examination, because these are the kind of questions which you will perhaps get in your Maharashtra CET examination. So guys, with this we come to the end of this session. Do follow us, do subscribe and press the bell icon on our YouTube channel. Do follow us on our Telegram. Do like our Facebook page, join our Telegram channel, follow us on Instagram, and do not forget to download the BYJU'S Exam Prep app. So with this, we come to the end of this session, and thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great year ahead. All the best. Prepare well. आपका preparation बहुत important है. अभी आपके पास 3 महीना ही बाकी है. अच्छी तरीके से प्रिपरेशन कर लीजिए. बहुत अच्छा रहेगा आपका एग्जाम। थैंक यू।